One of the areas of immigration law that keeps coming up and that is definitely not resolved throughout the country is what happens if you're in asylum status and you want to do an adjustment of status. As many of you know, adjustment of status is when you go from whatever status you currently have to a green card, adjusting the status, as opposed to a change of status, which is to go from one visa to another. And in general, in order to get adjustment of status, you have to be currently in good immigration status. If you're out of status, you're generally not allowed to do an adjustment of status unless you have some kind of a waiver. And there are a lot of different types of waivers, and it's a complicated area of law. I've covered it before. Certainly waivers are available, but they're not always available. Most of the time, the petitioner does not have a waiver available to him or her. What happens, you're in the US over many years, you came in, you applied for asylum during the first year of your stay, and then many years later, you applied for an EB application or a family reunification, and that application was approved, and you are going to now proceed to an adjustment of status. Are you eligible for an adjustment of status if you are under an asylum status? The answer for me is yes, and when I say for me, it's yes because the law says so. There are statutes, there are regulations that say that the moment you apply for asylum, you are freezing your status. The statute specifically says that no time after your filing of an asylum shall count toward unlawful presence. Now, some immigration officers have taken the position that having lawful presence is different than having lawful status. My position is that's nonsense. That's something, that's a regulation that the government has created out of thin air that is not in the law, that serves their purpose. That says, oh, well, yeah, you were here, you had lawful presence, but you didn't have lawful status. To me, that makes no sense. I have had many situations, many clients who were actually in asylum status for many years, and they applied for adjustment of status. They went to an interview with a 485 officer, and I told the officer, hey, look, this person has been here for 8 years, but they filed for asylum 6 months, 5 months, 8 months after they came. So they were in status since that day because they didn't get their asylum interview yet. However, that doesn't mean that they will accept it. But the law for me is very clear. I have filed papers, I have filed briefs in order to show and to support that position. And as I said, I've had many times successful 485 adjustments of status that were based on someone having an approved I-140 and being in asylum status. But again, as I said, there are instances where the officer will deny it, they will create something. In that sense, you have options. The option is if there's a denial, we can file for an appeal with USCIS. And if it's a denial that we don't think will be helpful to file for the appeal, you have the right to file a writ of mandamus, which is going to federal court to challenge the denial in USCIS or in immigration court. We currently have many cases pending in front of a federal judge who will adjudicate this issue. And if necessary, this issue will be taken up to the Court of Appeals because, again, from my position, the law is very clear. You have a right to do an adjustment of status if you're under asylum status. And especially since this past summer, the United States Supreme Court overturned the case previously known as the Chevron case, which allows judges to give deference to the agencies that have regulations. That is no longer the case. Now the law is that the judge is supposed to look at the statute directly, de novo, and make a decision on that, which, in my opinion, will increase the chances of judges finding that a denial is not lawful. So if you're in a situation like that, you can talk to us and we will analyze your case and we'll let you know if you're a good candidate for an appeal or if you're a good candidate for a mandamus, a writ of mandamus. But again, as you also probably know, you have limited amount of time, so you better let us know as soon as possible.